just 95 Act provision, they were all Muslims. Sure, now, sure. Yeah, right. Now let's kindly come to section 9 and kindly look at the section 9 as it was under the 1995 Act. And you will find in the footnote, Mullahs, the following members to be appointed from amongst Muslims. You see that at page 17 bottom. Last line at page 16, bottom, Mullahs, prior to substitution, subsection 2 stood thus.
You have that? Right at the bottom, Mullahs.
So the council shall consist of.
Yes, yes, prior to substitution. Right at the bottom in the footnote. That is the previous section 9, Mullahs. I'm just showing, Mullahs, what the change is. Prior to substitution, sub-rule 2 stood as the council shall consist of union minister, following members to be appointed by the central government from amongst Muslims, namely, all of them were to be Muslims, 3 persons who are eminent scholars in Muslim law, provided that at least 2 of the members appointed under subclause 1 to 7 shall be women. That's it. So, Mullahs, all of them had to be Muslim?
Judges. Even judges. Even members of parliament and judges.
Even members of parliament and judges had to be Muslim under the previous dispensation. It is true also of all the Hindu endowments, Mullahs. They all have to be Hindu, Mullahs. I'll show, I've given that in my note also. Now, Mullahs, if you look at the present section, which your lordships will find at 17 top, union minister in charge of Wakf, no reference to Muslim. 3 members of parliament, of whom 2 shall be from the House of the People and Council of States, no reference to Muslim. The following members to be appointed by the central government from amongst Muslim members. So 3 persons to represent Muslim organizations, chairperson of 3 boards, that is 3 by rotation, Mullahs. So therefore 3 and 1, 4. 1 person to represent Mutawalli, that is 5. 3 persons who are eminent scholars in Muslim law, 8. Correct, Mullahs? So the total number of Muslim members are 8. D is 2 judges of the Supreme Court or High Court. So therefore 2 there. 1 advocate of national evidence, that's 3. 4 persons of national evidence, that's 7. Additional secretary or joint secretary, that's 8. And Mullahs, the first 3, union chairperson and 3 members of parliament, 12. So it's 12 versus 7. So you can have 12 non-Muslims in a situation and 7 Muslims. And the previous acts are all Muslims. So in other words, the administration also is taken over. Proviso says only about 2 members of, excluding shall be non-Muslims. So that's the ex officio members. That's right. Provided further that 2 members appointed under this subsection, excluding ex officio members, shall be non-Muslims. At least 2 and up to 12. At least 2 and up to 12.
So it doesn't say at least, provide further that 2 members
appointed under this subsection, excluding ex officio members.
Shall be non-Muslim.
That's correct. Excluding ex officio members. So union minister is ex officio. Other may or may not be.
So then how do you say that there would be majority?
Because, because we are here, we are 10 only, 7.
So ex officio would be 1.
Only 1.
So the union minister can be both, either a Muslim.
No,
or
it's
not
excluding ex officio members, it says.
Yes.
Shall be non-Muslim. So it will exclude the minister.
Union minister in charge of the work is ex officio.
He's excluded, Malas. He'll be non-Muslim.
Then
Then 3 members of parliament.
so the other ex officer is only additional secretary or joint secretary.
That's correct. They'll be non-Muslims, they say. At least 2 of them says, no? Provided.
There is only one.
No, Malas.
Additional secretary or joint secretary.
Above 3 members of parliament also, Malas.
They are not ex officio.
No, correct. Correct.
They are not ex officio.
But
So
there's no requirement that they'll be Muslim, Malas. That's the point.
let us see. Let us read the category one by one.
Yes.
Where the Muslims are
Union minister, Malas, will not be Muslim.
either a Muslim or not a Muslim.
No, it says, shall be non-Muslim, excluding ex officio members.
Where does union minister in charge of work, a chairperson, ex officio.
Maybe, may not.
Either a Muslim may or may not
May
be
not.
Muslim.
But that's their choice, Malas. The point I'm making is that's their choice.
The cabinet doesn't remain same for the entirety.
No. That's not true in any other enactment, any other Hindu endowment, Malas.
So that will examine. You are saying that by this composition, the majority would be non.
Theoretically. I'm not saying.
Let us examine. So
That's right. That's what I'm saying. Now, let's assume that they'll be non-Muslims. Why, Your Lordship is assuming
let
that
us say union minister in charge of work, a non-Muslim. Let us assume.
one Malas. 3 members of parliament, non-Muslim. 4.
No. What does it say?
May not be, Malas.
Maybe may not be.
So I am assuming, Malas, they may not. Malas, I am theoretically.
Let us see
One
which are ex officio and which are not ex officio.
Correct.
So there are 2 ex officio.
Correct.
One is
Point
A,
secretary.
one is J and one is G.
Correct.
So assuming that there are 2, both of them are non-Muslim.
Yes, we'll assume that.
Yeah. Then under the proviso,
Yes.
excepting ex officio, there can be 2 members.
No. 2 must be, Malas.
Better we will call upon you when your turn comes. So don't show the enthusiasm as
Malas, just.
Priyanka is showing there that side. No.
I will make sure that I don't remind you of anything while you're.
Let us read it further.
Yes.
Therefore, 3 members of parliament of whom 2 shall be from the house of the people and
Correct.
one from the.
They may be non-Muslim.
They may not be.
That's 3. That's 3.
No, not 3. Provided that the 2 of the members appointed under.
House and 1 from Council of States. Malas, so 3.
No, it doesn't say, provided further that 2 members appointed under this subsection, excluding ex-members, shall be non-Muslim.
Just
So it doesn't say at least,
kindly see.
or,
Previous provision said 3 members of parliament shall be from amongst Muslims. In the footnote.
so B could be Muslim, non-Muslims also.
That's what I am saying, but he can be non-Muslim. Malas. I'm not saying.
So let us see where there is a possibility of non-Muslims being there.
Therefore, the possibility is 1 chairperson, 1, and 3 members of parliament. Possibility of being non-Muslim, that's 4.
Yes.
Correct, Malas?
Then-
Now you come to
Then
the Muslims.
3 is all Muslims.
3 plus chairperson of 3 boards by rotation, so 1, 4. 3 and 1, 4, Malas, by rotation.
Then 1 person,
Then 1 person to represent Mutawalli is 5.
5,
3 persons who are eminent scholars in Muslim law, 8.
8.
Correct? Now, correct. So therefore, 8 maximum Muslims. Right?
No.
Not
No.
Minimum.
8 minimum.
8 minimum Muslims. Correct. When I am assuming that all the others are non-Muslim, that's how I'm arguing.
So 8 minimum.
8 minimum.
8
Now,
are guaranteed.
guarantee. Malas,
Guaranteed Muslim.
that's the only guarantee we have in this statute. No ambiguity.
So-
Then 2 persons who have been judges of the Supreme
No,
Court.
so B could be either Muslims or non-Muslims.
Earlier they were all Muslims.
I agree. I am not disputing there could be Muslims. I am saying we are assuming now that they can appoint non-Muslims, that they are not prohibited to appoint.
No, but let us see. So that 3, then
3 plus 1, 4, Malas. Chairperson plus 3 members of parliament, 4.
let us exclude chairpersons and the secretary.
That's 4, Malas. Then you come to 4 persons of national eminence. That's 8.
2 persons who have been judges of the Supreme Court or High Court,
Yes, that's 2. Non-Muslims can be.
non-Muslims.
So
can be-
therefore, 4 plus 2, 6.
Yeah.
then one advocate of national, that's 7. And then 4 persons of national level, that's 11. That's what I was telling your lordship. An additional secretary, 12. That's what I was saying to your lordship.
Provided that 2 of the members appointed under subsection C shall be women.
Correct?
Now let us see, provided further, that 2 members appointed under this subsection, excluding ex-officio members,
Shall be non-Muslim.
shall be not.
Correct?
So the number is restricted to 2. It doesn't say at least 2 or, it says there are 2 or more.
It's not limited to 2, but that's the minimum, Maharaj. I mean, the maximum we can have a guaranteed ones are 3 plus 1 plus 1 plus 3. 8. That's all. Theoretical. I'm not saying that they will not be Muslim.
The second proviso, the word used is 2. It
Yeah.
doesn't say at least 2.
Excluding Maharaj. Excluding the ex.
It says excluding 2, so at the most, if this 2 plus 2 ex officio, it will be 4.
That's correct. That's correct. But they may not all be Muslims, Maharaj. See the previous section in the note, Maharaj, what it was. It's best we appreciate that, Maharaj. Compare it. Let's compare it. Excluding yes.
The same people will make money. It's a preceding thing.
Yeah. All of these were read in the line. I'm going to say, Now see whether the previous provision in the footnote. Now it will make it clear, Maharaj. The council shall consist of union minister in charge, ex officio. The following members to be appointed by the central government from amongst Muslims. So therefore, 3 are Muslims, 4 are Muslims, 3 are members of parliament
You are
Muslims.
right, because when you say that all these have to be earlier. Now, the only distinction which has been brought about is that there can be 4 people, 2 ex officio and 2 further people. That's the only.
No, Maharaj. No, your members of parliament need not be.
Therefore, maximum I'm saying 4.
There can be 12 non-Muslims because members of parliament need not be Muslim, Maharaj. So proviso, it doesn't say that the rest of them will be Muslims.
Proviso also does not say.
Yeah.
Because it is restricting non-Muslims.
I'll let for a moment assume, Maharaj, what the observation that's fallen from your lordship is right. I'll assume that, Maharaj. I'll assume that for the moment. If it is right, Maharaj, then what it means is that they can have at least 4 persons that are non-Muslims.
Yes.
That's what my lord is putting to me. Now, it's a departure from what? From the previous law where everybody had to be a Muslim? Correct, Maharaj?
Except the ex officio chairman.
Yes, exactly. Except that one, everybody had to be a Muslim. So they have departed from that entire regime. And your lordships are now interpreting to mean that other than these 2, everybody else will be a Muslim apart from the other 2.
So because your argument primarily was that the majority would be.
I see. Could be. That's, I still maintain that, Maharaj. Could be. Unless your lordships were to interpret that in such a way that everybody else has to be a Muslim, which is not reflected in the statute.
No, because the board uses second proviso, provided further that 2 members appointed under the subsection excluding ex officio members shall be non-Muslim.
Correct.
So if the word 2 members would have been preceded by at least, then there might have been substance in your contention that at least 2 and it can be up to all. Or all those, but it says only.
All right.
It specifies the word 2.
All right. Well, let me assume that, Maharaj. That's against myself for a moment. Let me
Also,
assume.
we can interpret it in such a manner that
That's fair.
there can't be more than two members except the ex officio from the non-Muslim category.
Correct. Anyway, according to me, 2 is too many also. But the reason why I'm saying this is that
2 is
in
not too many in 22.
every
2 is not too many in 22.
every religious endowment, Hindu endowment, does not have one person who is a non-Hindu. Not one person.
You must be aware about the debate going on about Buddha here.
But that both guys, Hindus and Buddhists, both.
They are only Hindus.
Both. The place of worship is for both. Act itself says that. I knew that example would come, Malas. The Act itself says that. But that's the only exception, but the Act itself says it. In all other Hindu endowments, there cannot be a non-Hindu. Same for Sikhs, Malas. Gurdwara Prabandhak Committee. Nobody can be who's a non-Sikh can be part of it. So why this exception? Assuming, Malas, that we interpret the section in a manner that only 4 will be non-Muslim. We'll assume that. But why should there be 4? Why should they be there at all? If you're giving that privilege to other religious communities, why are you not giving that?
That's a different argument.
I'm putting it like
It's a different argument also.
No, I'm saying on interpretation, I believe, but anyway, that your lordships can do it after the final hearing. At the moment, Malas, my request is nothing should be done till your lordship hears all these matters, Malas. Now, it's even worse, Malas, as far as the board is concerned. Now come to 14. Bodh Gaya Act in 11.1, it says Buddhists of every sect shall have, notwithstanding anything contained in this act or the rules framed thereunder, Hindus and Buddhists of every sect shall have access to the temple.
It's a place of worship of two.
Because it's a place of worship of 2 communities, both Buddhists and not only Buddhists.
And the composition is here only either Hindu or Buddhist.
No non-Hindu or no non-Buddhist can go there even. So, Maharaj, that's the scheme of a secular nation where you allow the community representation within the construct in terms of which the...
What are the functions of the council, by the way?
Sorry?
What are the functions and duties of the council?
Advisory functions. Advisory functions.
Are they given a role to
Yes.
interfere in the management of the particular work?
Yeah, your lordships will see. Advising the central government and boards on matters concerning working of boards and due administration of Wakf. Both. That's section 9, subsection 1.
So, section 5,
Yes, I'm going to.
any dispute.
They can issue directives, Malad,
No, advisory on matters concerning the working of boards
and Malad,
and the due administration of work. So
administration of the Wakf.
they can only give advice.
No, administration also. 1A, see 1A, Malad.
Advice with regarding to the administration.
Just see
of the work.
1A, Malad. The council, count 9.1A, council referred to in sub shall issue directives to the boards on such issues and in such matter as provided in subsection 4 and 5. Directives also. And what is 4 and 5? State government shall furnish information to the council on performance of Wakf boards. It's a direct interference in the administration of the board.
I will go to the Chief Justice.
And any dispute arising out of the directive shall be referred to a board of adjudication to be constituted by the central government to be presided over by a retired judge of the Supreme Court.
Substantive dispute.
So, Maharaj, these are huge powers vested in the council.
We will call upon them.
That's right. So now, come to now 14, Maharaj. Now, Maharaj, if you look at 14, all of them are nominated. No election. So all of them, in fact, boards are the entities, board is the entity which actually administers. And all of them are nominated. Right. I don't have to read the section, but it's exactly the same as the council, Malaj. The same provision. But except that these are all nominated. Now, let's. And that's all right, but they will be nominated Muslims. No, that's what I'm trying to say.
No,
To you.
earlier it said has to have 3 Muslims.
Ajad, I'm trying to say that only. You are insisting on something. Earlier it was elected, now it's nominated. That's all I'm trying to say.
Here, there is only one ex-officio.
That's right. That's correct. Only joint secretary to the state government. But all this is nominated. Now, let's see the previous section. That is at page 20, Millards, and the note. The board or the state, for a state and the national capital territory of Delhi shall consist of a chairperson, one or not more than two members as the state government may think fit to be elected from each of the electoral colleges, consisting of Muslim members of parliament. So even members of parliament will have to be Muslim from the state, or as the case may be, by the national capital territory of Delhi, Muslim members of the state legislature, Muslim members of the bar council, provided that in case there is no Muslim member of the bar council or the union territory, state government or the union territory may nominate any senior Muslim advocate, mutawallis of WAQFs having an annual income of so and so. So, and one person from amongst Muslims who has professional experience in town planning, one person each of amongst Muslims to be nominated by the state government from recognized scholars in Shia and Sunni Islamic theology, one person from amongst Muslims to be nominated by the state government from amongst the officers.
So this election is only restricted only to one or two.
Two.
One or two.
One.
So it can be minimum one or maximum two to be elected from
No,
four categories.
Number of elected members shall at all times be more than the nominated members of the board. Right, Mullah?
Where
Page
did you
20
say that?
at the bottom of 21. Clause 4, Mullah, earlier clause 4. At the bottom. Last clause.
Page 20.
Page 21. Footnote. The number of elected members of the board shall at all times be more than the nominated members of the board, except as provided in subsection 3.
Of the electorate.
And you see here, Malaj, one or more one and not more than two members of the state government may think fit to be elected from each of the
Each
electoral.
of the electors,
Yeah.
each.
That's correct.
So there could be one or two either from members of parliament,
That's right.
one or two from the members of state legislature,
Correct.
and a bar council
Yeah,
and mutawali.
correct. So the point is, Malaj, one, you start nominating the board, which is the central authority, which administers WAQFs. You nominate your own people.
So the power is not with the central government, power is with the state.
State, Malaj, yes. Yes, the government, Malaj. This power is the government, Malaj, either way.
State government.
Absolutely right. So that takes care of 9 to 14, Malaj. The very scheme of it suggests, Malaj, that you want to exclude us from every facet of activity in relation to the WAQF. So we are here now, Malaj. Anything else? Yes, Malaj, just so that your lordships may note it, I've given at page 11 of my note, Malaj, the spiral bound note, I've given Religious Endowment Acts. Just come to page 11. Even ex officio members have to be Hindus there, Malaj. There can be no exception. But bol diya na, I see you mentioned earlier.
53.
Page 11, if your lordship notices, Malaj. You want to take a minute? You want to take a minute?
Maybe.
Okay. Lordships have page 11 of my note. You will see there Religious Endowment Acts, Andhra Pradesh Act, Tamil Nadu Act, Uttar Pradesh Kashi Vishwanath Temple Act. It starts from page 8. The annexure of it is at page 19, Malaj, of these acts. So all of them, even the ex officio member, have to be Hindus. The idea is, Malaj, it's not about discrimination. Idea is this is part of my right to manage the affairs of the community. So it's part of 25 and 26. And that is all subject to health, public order, and morality. None of this relates to that. Your Lordship knows it says subject to public health, morality, and public order. What has this got to do with it? So just as educational institutions administer their affairs, religious communities administer their affairs. The Hindus do it, the Sikhs do it. Well, why should the Muslims not do it? Christians do it. And this is not secular. These are mosques, these are activities that are directly, the very creation of the Waqf is not a secular act. The creation of a Waqf is not a secular act. It's the Muslim's property which he gives away and dedicates to God. Somebody else can do the one. You want to do the data, this thing? Huh? This 116%.
I've got other data.
Okay.
It's like 5-10 minutes.
That's no problem, no problem. Well, I'm sorry.
Got it, add karna ho to I can add.
No, I'm not going to.
Add
Well,
some
just
data.
one last thing. They have made a submission, Malaj, that after Malaj, this amendment, in 2013, there has been a 116% increase in the registration of Waqfs.
By you.
And the idea being that how can it be between 2013, there's a 116% increase. Right, Malaj? Now we have an answer to that. They have not put it in their written submissions. Now you will deal with it? So my learned friend can deal with it. And Malaj, Dr. Dhawan wants to
No.
take a minute, no?
No, just a minute.
Just 1 minute, okay, and then you can do it.
I'll just take.
Okay. I'm deeply obliged to you, Lordship.
Just one second.
Yes, Doctor.
My lord, by straining my voice, I might strain your lordship's ears, my lord.
Sorry, we can put up the mic here.
My lord, traditionally, when we joined the bar, there were no microphones. We were taught to address the bar in full throat, my lord. Anyway, just 3 sections that I want to bring to your lordship's notice, my lord.
Now also, when Mr. Ranjit Kumar argues in the adjoining court, we can hear him in this.
My lord, he's in a class by himself, my lord.
Lord, during COVID, when we were appearing virtually, somebody said that, Mr. So-and-so, you are on mute. And I said, even on mute, he is heard.
My lord, just 2-3 sections, my lord, and then I will conclude, my lord. My lord, kindly turn to your lordship's book.
Yes, yes, to make an atmosphere like.
Justice Kuldeep Singh and Justice Verma were the other 2 courts, my lord. And the summer of the court was open, so they were commissioning from inside also, help inside. So of course, there was no mic those days, 1996, 97. Both those courts could hear my voice. They had to close their doors and the students.
Lord, there is a real life story. Mr. Dhawan, Dr. Dhawan would be aware. Lord, once Winston Churchill was sitting in his chamber in the parliament. And in parliament, it is believed, my lord, in those days, that in the lobby there used to be telephones to be used by the members of parliament to talk to their constituents in their constituency. And somebody was speaking very loudly. So Churchill asked him that, who is this man and why is he shouting? His PS said that he is talking to somebody in his constituency. Churchill said, ask him to use the telephone.
My lord, my anecdote is, I told Justice Ramanna, as he then was, that I don't suffer from blood pressure. So he said, you give other people blood pressure, that's the reason why. But at any rate, my lord, levity apart, my lord, may I take your lordships to section 104, my lord, which is on page 76
Of the new act.
of the new act. Yeah, no, page 76, yeah. I will, it's all right.
104.
Now, my lord, your lordships will see the title is Application of Act to Properties Given or Donated by Persons Not Professing Islam for the Support of Certain Waqf. Now, kindly see, my lord, the original act that your lordships will see on the next page in a footnote. Permit me to read it, my lord. Notwithstanding anything contained in this act, where any movable or immovable property has been given or donated by any person not professing Islam for the support of a waqf, being a mosque, idgah, imambada, dargah, khanqa, maqbara, Muslim graveyard, chowtry, or muzaffar, then such property shall be deemed to be comprised in that waqf and be dealt with in the same manner as to the waqf, as the waqf in which it is composed. I'll make a point on this in a moment, my lord. Then kindly turn to section 23, my lord. I'll just read, my lord, the now, if your lordships will see that it says there shall be a full-time chief executive officer of the board to be appointed by the state government, who shall be not below the rank of so-and-so. Now, my lord, kindly see the original section. There shall be, at the bottom of that page, my lord, there shall be a full-time chief executive officer of the board who shall be a Muslim. I won't read the rest, my lord. There are at least 12 sections of this act which deal with the powers, duties, and responsibilities of the chief executive officer. One more section and I'll make 1 or 2 points, my lord. Now, my lord, kindly come to section 2. This your lordships will find on page 5. The lordships will see that a proviso has been added. Provided further that nothing in this act shall, notwithstanding any judgment, decree, or order of any court, retrospective, apply to a trust by whatever name called, established before or after the commencement of this act, or statutorily regulated by any statutory provision pertaining to public charities by a Muslim for a purpose similar to a waqf under the law for the time being in force. My lord, I won't elaborate other than judgment after judgment of your lordships, my lord, have indicated that a waqf can be in the form of a trust. And eventually, earlier, my lord, the board decided whether it was to be a trust or whether it was to be a waqf. Now, this was a very important provision, my lord, right from Ratilal, the first decisions of your lordship, 7-judge bench. There has never been any doubt that if your objectives were in the form of a trust, similar, and those are the words used here, my lord, similar to those of a waqf, this will entirely and completely disappear. Now I will make, my lord, 2 very general points.
I didn't get you.
My lord, earlier, supposing I am a Waqf, my lord, and I create a trust which has objects similar to that of a waqf, it would be in the past treated as a waqf. Now, my lord, many, my lord, Waqifs put their objectives, ultimately, remember, my lord, it's the object of charity, object of religion. Now, if the object of the trust is similar to that of a waqf, and there were a large number of them across the board, my lord. Ratilal, my lord, is a case from Bombay. It dealt with the charity commissioners, and the issue once there was whether the charity commissioners would have control or whether the Waqf board would. And your lordships ruled that if it is similar to a waqf, then, my lord, it is not the charity commissioners who will appoint, my lord, the custodian.
But the board.
With the board, or the board as it then stood, my lord. Now, this is an important takeaway, my lord, because a large number of Waqfs are in the form of a trust. What this does is, what was earlier a matter of form has now been removed as a matter of substance. Just 3 points on that, my lord, and 2 additional points I want to make.
What you are trying to say is basically that any trust would not be a Waqf anymore.
That's right, my lord. Even if it is similar, my lord, trusts are in their own area.
So that's right.
That there is a
think
distinction
that-
between the two.
Yes.
But if it is similar to the nature of a Waqf, it would be treated as a Waqf.
Correct. That's
And there are a large number of such throughout India. Now, my lord, I have 2 more points to make, my lord. My lord, Mr. Sibal has already indicated, and this has never happened, my lord, in the past, of the redefinition of a religion and religious property. Never before, my lord. We go back to the Board of Revenue of 1810, my lord, of the East India Company. They didn't change the nature of the Waqf property. Neither 1817 in Madras, nor in the 1923 Act, my lord, nor in the 1994 Act, nor in the 1995. What was the occasion, my lord, for this large-scale liquidation of the very concept of Waqf? My lord, no religion in the world can survive apart from belief, practice, property. You take that away and no religion will have any longevity at all. So this goes to the heart of every religion, and it is only the Muslim religion where this property has been dealt with in this way. But that is not my only point, my lord. The important point is, my lord, it's an issue not just, my lord, as far as this is concerned. My lord, we are a secular nation. One of my clients, my lord, in the writ petitions, not listed before your lordships, happens to be a Sikh. He says, I want to contribute to Waqf. I believe that this property should not be taken away. This is an issue which goes fundamentally to the question of secularism, Lord. Because Article 25 and 26, and I would add Article 29, the preservation of one's culture. That's right.
Article?
Lord, 29 as well, which is the right to preserve your culture. How would you preserve it, my lord? You preserve it on the basis of your beliefs. You preserve it on the basis of your practices and on the basis of the property that sustains these beliefs and practices. Take that away, my lord, the entire secular edifice which your lordships, my lord, have built from time to time and time again, my lord, will also become suspect. One last point, my lord. Mr. Sibal has dealt with, my lord, classification, manifest arbitrariness. My lord, when you justify these changes, what is your justification? What your lordships, my lord, have laid down is the doctrine of proportionality. Where is the proportionality? Now, they, on the other hand, says there is better effective management. At one stage in the counter, they say certain persons were not registering as Waqf by user. So, my lord, the question that your lordship might put to them is, you want to achieve certain goals. It has to have a nexus that's established. Where is the proportionality behind the changes that you are now making in relation to the objectives to be achieved? And my lord, across the board, no justification has been given as far as proportionality is concerned. My lord, I adopt the rest of the arguments.
It was a pleasure hearing you after a long time.
I know, my lord. Even in my throaty voice, my lord. My lord, there's one small point, my lord. This act is in the teeth of a large number of Constitution bench decisions of your lordship. Charity, Ratilal, Babri Masjid, my lord, para 1131, which says Waqf by user is a part of Islam. So it's in the teeth of a number of constitutional. Now, my lord, your lordship interpreted in TMA Pi the meaning of the word establish and administer.
It's 1134 paragraph.
1134. That is in M. Sadiq, my lord, the Babri Masjid case.
2021 SCC, page 1.
So, my lord, now, my lord, the question as to whether educational establishments also came in TMA Pi, in para 25 and 26 of TMA Pi. The phrase is establish and administer. I have a right to establish, my lord, under 26B of the Constitution. I have a right to administer. Those rights, it is stated way back in 1954, no legislature can ever take them away. That's all. I'm very deeply obliged.
Please, Your Lordship. So I will finish even before possibly the end. Very pointed.
Bear down your.
It's difficult to navigate what is left over, and I'll try to just give you lots of points without repeating.
Let's all shift.
Incidentally, well, it's the first learned judge who could be heard holding his own court in Supreme Court and other courts came from my state. And the second learned judge,
Of course,
there were two learned judges, Malas, who could be heard in other courts.
yes.
One from Rajasthan in the old days and then one from Mumbai. Justice Tulsapurkar, Justice Bhargav, who was the uncle of Justice Suresh Agarwal. They are the two learned judges you could clearly hear them in those days. Anyway, now, Malas, the first point, and I'll make it only point formulas. 3R, Your Lordship has seen. Just pick up 3 small r for a second. Now, 2 points have already been made in the text of it. Your Lordship, page 7 of the Act, perhaps. The 2 elements there are, one, proof of your practicing Islam. And the second is this delightful word, contrivance. So the first thing is, Wallace, that you can never apply, look at the word, Wallace, and that there is no contrivance involved. It's a recipe for making the applicant visit the offices of the collector or the officer for eternity, trying to prove that there is no contrivance involved. It's the most vaguest, arbitrary, completely whimsical word used to invite terror, control, and endless visits to the government office. Second, people of all religions make religious endowments. All. And India is, planet Earth's most diverse spot. Which other religion, at the point of making a religious endowment, by whatever name called, is asked for proof of that religion's professing and practicing? For 1 year, forget 5 years. For 5 years, for 10 years. Which religion? Point number 2. Point number 3. That brings in directly an article not really directly mentioned, Article 15. This provision goes on the short ground subject to my Lord's discretion of violating Article 15. Textually, it is a discrimination on ground of religion. Religion X and its donors and its creators of religious endowments are asked for proof of their religion, which is directly contrary to Article 15, which Lordship knows very well, Mills. Out of 7 or 6 tests, the first word is religion in 15.1. The state shall not discriminate against any citizen on grounds only of religion, comma, and this is only religious, race, caste, sex, place of birth, or any of them. Religion is the first. And it is singular, Malas, in its novelty, the state is discriminating by using parliament to pass a law, and therefore that law is unconstitutional. Whereas my second point relates to the Wakf by user point and goes slightly beyond. It has already been made. I only want to fill up a gap. By its very nature, Wakf by users were largely unregistered. At some point of time, a requirement came to give particular register, be there aside for a minute. Whereas the subpoint in 3C and all the other provisions there is the access to court point, the remedialist point. Now, my learned friend has already shown to your lordships the arc which connects 3C, 36.7, 36.7a, and 36.10. That must be kept in mind. And well, it's a vicious circle that once you cease to be Wakf, you cannot exercise the remedy, principally because you're not a Wakf. So it's trying to catch your tail. The ground.
But please repeat your submission.
This arc is very interesting. Just let us pick up 36. 3C, my lord, has seen dispute. The counterpart of 3C is found in 36.7a. My lord has noted that. There also a dispute means you're not a Wakf. So one principle is in this act. The moment there is a dispute, a Wakf, so-called a Wakf established, a Wakf 500 years old, ceases to be a Wakf.
That's what.
Both 3C and 36.7a.
That's what Mr. Sibal are also.
Yes, but I'm not on that. I'm now on the access to justice. Now, the moment you cease to be a Wakf, there is no question of registration or unregistered Wakf moving a court. And the bar of 36.10 applies in full force. That's why my Lord Management read to worship 36.10. So I say it makes a vicious circle that any dispute, and the dispute can start tomorrow. It doesn't have to be a pre-existing dispute. It doesn't have to be a dispute leading to a decree or a appellate decree or a Supreme Court decree or prior to this date. It can be a dispute started tomorrow. I can start a dispute tomorrow. So that is clearly exclusionary. Now, what I'm going is one step further. I heard an interruption saying the 36.10 was always there. That is more than a half truth. Please note what was the 36.10 predecessor. Give this note. Come on quickly. This is not a note for reading, but it's just for the quotation I've given you, so it'll be easier. Please ignore all the text. I'm not giving it to the side.
Note at the end. I know you just
can I read a provision of statute from a note? Yes.
Not note.
Mr. Mehta, I hope that's not your best point, Mr. Mehta.
No, that's
Now let us come to page. Kindly come to page 4. Till now, I have not read the note, but I'm in terror. I'm reading only the provision from the note. Para 7. Now, this is important. Well, let's just don't read it for a minute. Give me a minute, please. In the 1984 Act, there was a bar of initiation of proceedings.
You're reading paragraph?
Well, it's 7 at page 4 of this note. Just the quotation I'm using it for. Does I not have it? See the underlined portion. Unless such Wakf has been registered. Right, brothers? Now your lordship will note the next line. The amendment was not brought into effect is an admission and a fair statement by Mr. Mehta at page 36 of his counter, para 55. That italicized statement by me is a quotation from Mr. Mehta's counter, page 36, para 55. I hope I'm clear, Melissa. So a broad ouster clause was never brought into effect according to the counter. Now, the next provision quoted is a provision in the 95 Act called Section 87. I hope there's a misprint there, that section should be 87. If there's a misprint,
that is correct.
Corrected. I'm grateful. Now, this is another, the wordings are not identical. We are not concerned with that. Again, another kind of ouster. See the underlined portion, unless such Wakf has been registered. Right, fellas? This was deleted by the 2013 amendment. That's why I said it's more than a half truth. From 2013, this deletion stands. This vicious circle of connecting 3C, 36.7, 36.7a and 36.10 starts only with this 2025 regime. I hope I am clear on my second point. My third point is, Malats, about that ancient monuments, where Mr. Ahmadi has made a very comprehensive note, which I will not go into. Just
this side will have to conclude by 4 o'clock.
I will conclude in
We have already granted more than.
Yes,
I have started at 3:35. I'll conclude.
No, we don't know.
Well before that, I'll conclude.
Well, we had said 2 hours, but we are again more. If we continue till 4 o'clock, we will be giving more than 3.5 hours.
I will conclude, my lordship may not doubt that at all. 100%. Even if I don't conclude, I shall conclude.
No, the others are in waiting. So
Yes.
everybody would like to.
Now, let me just say what I wanted to say on this, just for a minute. On 3D,
if something is left.
No,
I'll try and leave.
no, not more than 4.
Let's finish. Let's use the time we have.
Yes. Since 20 minutes are left,
Yeah.
we thought that Dr. Singh would be generous for others.
My lord, 4 minutes for me, my lord, because I have.
This will take away my 20 minutes. So let me finish as soon as I can.
After that, when I finish, my lord will consider that.
Now, Millis, the 3D, number 1, Millis, 3D, all the other facets of 3D I am not repeating. That has been argued. 3 capital D. Millis, it would, read as it is being read by the government, would even circumvent and impinge upon the Place of Worship Act, 1992. Clearly. Your lordship reading it differently is something else. I'm not concerned about how lordship read that, of course, can be protected. Lordships can read it. As textually framed and as argued, this non-obstant situation in 3D, superimposing Ancient Act, Monuments Act onto this, superimposing 2025 Act on the Ancient Monuments Act, has a direct result of affecting even those protected by another special act called the Place of Worship Act 92. Effect of the Places of Worship Act 1991. I'm sorry, 1. Because something, let us say, a character of a place of worship, which is X religion, Y religion, Z religion, is shut off on a cutoff date. Today, by a notification here, for example, for Muslim places of worship, you will create a situation where at least your lordship will have to work it out. Otherwise, on a literal interpretation, it will override that. The second point on that is...
So work out what? Work out what? You said that we'll have to work out.
No, your lordship, unless absent your lordship's interpretation that the Place of Worship Act protection on a cutoff date remains a Muslim place of worship, a place of worship.
Ancient monuments.
I am arguing Place of Worship Act. I am not arguing Ancient Monument. I am saying if you notify under the Ancient Monuments Act.
According to him, by superimposing
Yes.
the Ancient Monuments Act on the by 2000
The declaration under
Act
D.
also affects the rights available to the citizens under the Right to Worship Act 1991.
It's not even an argument to be dealt. I'll deal with it.
It is my argument, not your argument. Because you haven't.
But is it a pleading?
Yes.
It is a pleading. It is a pleading. We'll give that also. Take it out. It is a pleading.
In fact,
Because
that overrides all other laws.
a Malad's monument, which is a monument which is protected under the Place of Worship Act, can be declared under a notification under 3D. That is the point I'm making.
3D, there is no notification.
3D opens the word notification. Allow me to have my 15-20 minutes. Let me have my fundamental right to say wrong things.
15-20 minutes?
No.
You decide about yourself.
He is not allowing me my fundamental right to say wrong things, your lordship. What do I do?
Then
He is interrupting me every sentence.
We don't mind, but then we will not be
No, no,
anyone after
I'm
that.
trying to finish. That's it. The next point here is Article 15 comes in again. Because on 3D, your lordship has chosen one religion in this act. Not your lordship, but the act has chosen. One religion.
So this act itself is applicable to one religion.
That's right. Now this
Very
particular,
question of
this
3D choosing one.
this act applying this interpretation of the Ancient Monuments Act to one religion is what hits Article 15. That's my point. The fact that 3D textually applies the Monuments Act on this act and this act on the Monuments Act is only for one religion. That's Article 15, Manas. Your Lordship is considering prima facie constitutionality and whether to give Manas some interim orders. Therefore, this is very relevant. Now, Manas, this is as far as 3R and 3D is concerned. Lordship may also note that your Lordship knows the law very well, that your Lordship doesn't normally grant a stay. But look at the language your Lordship used in the Farm Acts case, kindly hand over that case. Bernard, give that case. Rakesh, give it quickly. 2021, 1 SCC 590. Rakesh Vaishnav, about giving us, we are not asking for a stay on the whole act. We are talking of the provision Lordship has heard us on. All these provisions. My Lord has said this about the whole act. Kindly hand it over.
This was an unopposed order. We conceded. Let us, you be clear and honest about it. Justice Bobde's order, Madam.
I can't be clear and honest about anything before opening the book and reading the case. Kindly turn to Wallace. Para, give me that book. Give me this one. Yeah, right, you don't. Just give me 1 second, Wallace. Para 10, 11, and 14. If my Lord comes to 10, let us see what the Attorney General said, and let us see that the last interruption of Mr. Mehta was right or wrong. Please turn to para 9. Para 9. It starts at when we put across above suggestions. Got it, Your Lordship got that? Para 9 starts like that. The learned Attorney General, even while agreeing for the Constitutional Committee, vehemently opposed the grant of any stay of the implementation of farm laws. I don't know what that English language means for us. Next page, continuation para. The learned Attorney General contended that the court should not stay the implementation of the laws. That was para 10. Though we appreciate the aforesaid submission of the learned Attorney General, this court cannot be said to be completely powerless to grant a stay of any executive action under statutory enactment. Even very recently, Jayashree Lakshman Rao Patil. Now come to 14. I agree with this. Your Lordship doesn't grant it for the asking. But if there is one act, one statute, one case which cries out for certain absolutely sinister provisions requiring to be said, this is it. Having heard the different perspectives, we deem it fit to pass the following interim order with the hope and expectation both parties will take the right spirit attempt to arrive at a fair, equitable, just solution. The implementation of the 3 farm laws, all the laws are listed, last line, shall stand stayed until further orders. As a consequence, the minimum support price in existence before the act shall be maintained. We are asking for much, much, much lesser ones. We are asking for much lesser. Then, Malas, your Lordship's recent judgment on 300A, authored by Justice Gawai, Chief Justice Gawai Malas just a few weeks ago. I'm not saying that Malas is all, but just note the citation. 300A.
The Karnataka matter.
Yes, Malas. Called Malas Bernard Vaz. 2025 SCC online SC20. Don't read it, just bear with me, Malas. Kindly note the citation. Court Master will do it. Paras are 42, 43, and 56. The important point is that your Lordships could have decided on the Karnataka statute about delayed compensation. My Lords made it a point in para 42, 43, and 56 to say that what must imbue your Lordship's interpretive approach must be 300 capital A. Namely, how you will interpret a provision, What will be the effect of that interpretation if it is expropriatory? And we have shown in detail what is expropriatory. I don't have time to repeat that. It will be imbued by what your lordship calls in those paras 42, 43 and 56. It's not a mere statutory right. It's a constitutional right. It may not be a fundamental right, but it's much higher than a statutory right. That's what your lordship says. So kindly note these three paras, 42, 43 and 56. Whereas your lordship has got this thing about increase of trust by 100%, etc. properties. Just note this, Melis.
42, 43 and
56. Where is that? Whereas it is said, one of the arguments in the counter is that there is a huge surge in Wakf properties. Suddenly, huge surge, explosion in numbers. Just note the answers were A, B, C, D. A, the loading on a portal which they've created for listing Wakfs started in 2013. The loading onto the portal. That is pointed out in my rejoinder at page 5. Lordship may just note it for saving time. Therefore, as the portal was populated over time, the numbers had to increase. Before that, you had no population on that portal. They are treating an increase in the portal population of listing as an increase in Wakfs. Updation exercise. Number 2, the learned Minister of Minority Affairs on 18th of July 2019 at the rejoinder page 60 of Mr. Ayubi's file. Mr. Ayubi's writ at page 60 has the answer to an unstarred question. He says we have increased now and are proceeding day to day on increasing digitization. So what is being prejudicially suggested to your lordships to increase numbers of Wakfs is actually an increase in the portalization and the digitization. Thirdly, there are many properties in a Wakf area sometimes. They were treated as one Wakf property. Now each is listed separately. This is all stated in my rejoinder. So let us not have these prejudicial arguments in the counter that there is an again and again a lot of prejudicial arguments are given. That you must have more and more, you are having a explosion. Your lordship should be aware in this note. Just turn to one fact. All we are talking in the abstract about registration and non-registration. In this note at page 2, extract from the JPC. Just see this for a minute, the note I gave. We are talking in the abstract about registration, non-registered, work by user, etc., etc. 2 figures only your lordship will note. This extract at page 2, 2 minutes more, 3 minutes more. For the state of Bihar, now the Bihar Wakf Board filed a document before the JPC. It's only extract from there. It is an annexure to the JPC, it's extract from there. Out of 20,000 mosques, only 5.98% are registered. Just note that one line. And
not.
Second page, which is an extract. And the second line is, on 27,000 graveyards, 3.6% are registered. This is from the Bihar Wakf Board's written submission and annexure to the JPC report. And note my learned friend's counter with annexure at 195. Mr. Mehta's. Page 195. PDF page 197, please.
Zero.
He says 50% roughly are Wakf by user. The figure he gives is 8.72 lakh properties, of which 4.02 are Wakf by user. Only that one line also save time. His own counter, annexing as part of the JPC extracts, says that. But there are some more things, but I'll give it in a note if necessary. One last thing, and I'm getting with you. But it's just these pages, reference your lordship, we don't because we have time to see it. The reference I gave last was about the 195 of the counter, where the annexure is given, which says out of 8 lakh, 50% are Wakf by user. Well, there's 2 more statistics that I'm done. Para 80 of Mr. Mehta's counter. para 80, one second. Para 80 of his counter says, those works which have not been registered, nor have they been found in existence during the survey by the Survey Commission, their claims are not maintainable at this belated stage. This is para 80 of his counter. The emphasis of the word survey by the Survey Commission. Well, as your Lordship will note, the JPC report at page 92 points out that survey is done only in 5 out of 28 states. It's a travesty. Just note the reference, page 92 of the JPC report. My friends, counter doesn't point this out. 5 out of 28 states and 4 out of 8 UTs.
New facts.
This covers JPC.
Just filed a note with new facts.
I have not filed a single note. I am quoting from your counter. I have quoted from your counter and the JPC report. Please don't misrepresent. Please don't misrepresent. Now, 9.3% of the area of the country as a whole is what these 5 states and 4 UTs represent. You do a survey in 9.3% of the area. In your counter, you say that in our survey, we found no registered works.
Not survey.
Your survey is only in 5 out of 28 states. And then you try to shut me out. I'm deeply obliged.
May I just take two? I'd like to take 2 minutes. Just there's one aspect which your lordships.
I won't get a turn.
Your lordships were, there's a point where there was some concern expressed by the court.
We don't detain you anytime. We are not detaining you on a single day.
I have to seek a lot of
We quite appreciate your difficulty. You have to be at the right time before the other court.
Today, Lordships can't say that. Can't say that.
Lord, I just want to answer one aspect because your lord, several questions fell from my lords when my learned friend Mr. Sibal and Mr. Dr. Singh were arguing, was with regard to the mandatory registration requirement. So I just want to place the correct position with regard to that. Plus, there's a 1923 Musalman Waqf Act 1923. Is the first time, it's not registration, the first time a requirement came for declaration. Under Section 3, a declaration was to be made to courts with regard to Waqf, and Section 5 required some accounts to be maintained. In that act, the responsibility was of the Mutawalli, and under Section 10 of that act, the penalty, Section 10 of the 1923 Act, my lord may just note, the penalty was 1,500 rupees, and for repeat offences, repeat subsequent offences, 2,000 rupees was the penalty. Section 10 of the 1923 Act. Section 3 is the obligation to furnish information by making a declaration to a court. Section 10, penalty on the Mutawalli was 500 rupees for the first offence, first conviction, and 2,000 rupees for all subsequent convictions under Section 10. Then comes the 1954 Act, which is the first post-constitutional act, which is the Wakf Act 1954. Chapter 4 provides for registration of Waqfs by the Mutawallis. Section 41 of the 1954 Act provides for a penalty of rupees 1,000 for the first conviction for non-registration, and for subsequent convictions, if there is a subsequent conviction, the removal of the Mutawalli under Section 43. The Waqf doesn't go, the Mutawalli goes under that provision. Then, my lord, comes the 1995 Act. And in the 1995 Act, my lord,
what is the provision in the 54 or 58 Act?
In the 1954 Act, Chapter 4 provides for registration of every Waqf by the Mutawalli. Chapter 4 is Section 25 onwards. Section 41 provides for penalty of rupees 1,000 for the first conviction. And under Section 43, if he is convicted a second time, the Mutawalli suffers removal without his rights as a beneficiary going, but as Mutawalli, he gets removed from the Waqf. That's the only consequence. Now, my lords, comes the 1995 Act, which is the present Act. 2025 is an amendment. Now, Section 36 in chapter 5 provides for registration of Waqf from 1995 till today, till 2025. And section 61 provides for penalties. The penalty in section 61 for A to D, A is registration. The penalty for a violation of A to D is a fine of rupees 10,000. And for E, F, G, H, which are most grievous things, which don't have to do with registration, but with taking away work properties, etc., is imprisonment for 6 months. Now, even today, even in the 2025 amendment, the penalty for non-registration has been just increased to 25,000 rupees on the Mutawalli. Non-registration does not carry any other consequence except a penalty on the Mutawalli. Even in the 2025, it's only a 25,000 rupee fine, which is imposed on him. So now please see the definition of beneficiary in 2A. My lord may just note it. This is a very unique situation right from the 1954 Act. The exact same definition of beneficiary is there. And in Waqfs alone, unlike other trusts, not just the people who benefit from it, but the objects are a beneficiary. So if my lord just sees the definition of beneficiary, and from 1954, 1995 and 2025, beneficiary means a person or object for whose benefit a Waqf is created and includes religious, pious and charitable objects and any other objects of public utility sanctioned by the Muslim law. The same definition, 1954, 1995, 2025. So the beneficiaries can't be made to suffer for the offense committed by a Mutawalli. That is the whole point. The objects of the Waqf don't disappear. Because if the Mutawalli has not gone and registered, or suppose there's some impediment on registration, he was not able to find the records, etc., or for whatever reason it's not registered, neither the objects can go, nor can the beneficiaries who are the who benefit from it can be deprived of that. And that is why, my lords, no law, including 2025, has a consequence of Waqf vanishing. Now, 2025, by the other provisions in 3C read with 36, 7A and 10.
7, 8 and 10.
Yes, there the entire Waqf vanishes due to non-registration. That is why, my lords, it's very, very egregious.
Can I start tomorrow at 10?
Just hear him for 5 minutes. Just 5 minutes.
Now notes can
We had requested all of you to share your time within you.
No, just one thing. Our note, the spiral bound note, we had, as your lordship director, we had shared our points with Mr. Singhvi.
You give a consolidated.
No, that is a consolidated note. So your lordship, read that note as our submissions.
This is spiral one is the consolidated note.
You please read that as our submission.
My submission is.
Yes, yes.
It contains submissions of everyone.
Yes, I have incorporated.
In vacation, we don't want to just use note and that.
I didn't argue those proportionality, all.
But that may be read.
Commercially, Dr. Singhvi argued.
It's all in the notes, mother.
consolidated note. Mr. Singh's note contains everyone's argument.
Mr. Izaz is prepared. You are prepared.
Yes.
My points are in that note. Your lordship may
Just
kindly.
let him say a few words at least.
Let Mr. Ahmadi, my lord, give
Just a
him
few words.
2-3 minutes.
Okay, we'll give 5 more minutes. Yes.
That's all.
I leave it to your lordship, Mullahs. I wanted to assist your lordship. If your lordship feels, Mullahs, that...
We know that you all of you are prepared, but they
I don't want to say anything.
no, therefore we had requested Mr. Civil the other day that please apportion your time. We will also not give more than tomorrow to the other side also. That they have to.
Exit 2 hours is.
Whatever time we have given it to them, we'll give it to you.
I'm not followed on that.
Ordinarily, in the opening,
They
Mullahs, council takes a
crossed
little longer.
Much
to be
beyond
able
2
to-
hours.
On an interim
Because
meeting.
some facts are to be stated.
Yes,
Now, just very quickly, Mullahs.
Yes, please.
May I just very quickly state a few points, Mullahs? I have prepared a separate note.
No separate.
Separate. note.
Otherwise, you take this note back and give us a
No,
consolidated.
very well. Mullahs. Then I will not go through that. Mullahs, just 2 aspects that I want to highlight. Just, Mullahs, have the act. If your lordship just has section 108 and section 107. The impact on evacuee properties is quite substantial. Now, 108 was already read to your lordship.
Dr.
Yes.
Dhawan read it.
Yes, Mullahs. Now kindly see 107. Does your lordship have 107?
Yes.
On and from the commencement of the Waqf Amendment Act 2005, the Limitation Act 1963 shall apply to any proceedings in relation to any claim or interest pertaining to immovable property comprised in a Waqf. Coalesce it with Section 108, which deletes evacuee property. Now, the effect of 107 and 108 together is that evacuee properties are out by virtue of Section 108. So, therefore, a registered Waqf in relation to evacuee properties by virtue of deletion to Section 108 gets obliterated. Now, today, my lords, by virtue of Section 107, if I want to challenge any such declaration of evacuee property per se, that will be hit by limitation.
That will be hit by?
Limitation, because the Limitation Act applies. So those declarations, my lords, which are age-old, which were protected by virtue of Section 108, that those Waqfs existed by virtue of Section 108, because the number of evacuee properties which are declared as Waqfs are huge in number. Point number one. Because for paucity of time, I'm not elaborating those points. Point number one. Point number two, my lords. So far as Section 3D is concerned, 3 capital D. Plus, I won't read 3D again, but your lordship recollects the text of 3D. What 3D says is that any property which is declared as an ancient monument and either under the Act of 1904 or under the Act of 1958, that declaration shall be void. Now, Marad, just contextually, the history has been explained. The Act of 1904 and the Act of 1958 has listed several properties, including, my lords, ancient mosques. Now, at the time, my lords, of the 54 Act, 23 Act, my lords, only applied, my lords, in respect of declarations. So under the 23 Act, all that you have to do is seek a declaration before the court. That's for the first time that the provision for declaration came. The 54 Act, for the first time, my lords, made registrations compulsory because it says it shall be shall. Now, even if I have a registered Waqf, under the 54 Act which I have registered, under the 1995 Act registered of any nature, whether it is Waqf by user or otherwise, all of them get obliterated if on the date of the registration prior thereto, this was declared, my lords, as an ancient monument. So ipso facto, my lords, A, it is retrospective. And second is, my lords, by virtually by the sleight of a hand, my entire Waqfs, all of them which were registered earlier, my lords, completely gets obliterated by the operation, my lords, of Section 3D. Now, the reason why, my lords, the argument, the submission, my lords, on Article 15 is extremely important is that there is no similar or analogous provision in any other act with relate to any other relation.
That is what Dr. Singhi also argued.
Correct.
So, Article 15.
That's correct. So, my lords, this only singles out one particular community. And, my lords, that also happens to 3E, because insofar as tribals, scheduled tribes are concerned, even, my lords, the very same provision, my lords, applies. So that's, my lords, the additional point that I wanted to make. The third aspect, my lords, of this particular of 3D is your lordships, my lords, under an interim order have restrained any further suits which are impinged upon by the Places of Worship Act of 1992. Now, the effect of 3D is that even those ancient monuments, my lords, which are protected specifically by your lordships interim order, will all get resurrected because the government today can say that so far as those particular places of worship are concerned, I will regulate the manner in which the practices are to take place. So today you may say you will not use it for any purpose whatsoever. By virtue of 3D, that is the effect of 3D. So that therefore, my lords, that's an overarching provision. Fourth point, my lords, just very briefly I'll make it. I made my point on evacuee property. I made my point on limitation. Just one more aspect, my lords. The expression practice of Islam for a period of 5 years, and my lords, that aspect of contrivance.
5 years.
5 years. Now, my lords, firstly, the point has been made that, my lords, in any other endowment act today, if I want to endow a property for the purposes of for a temple, there is no restriction, my lords, that I have to prove that I am practicing that particular religion for a period of 1 year. That's point number one. The second aspect, my lords, is how will you determine this factually? Is there an ascertainable principle by which you can determine this aspect as to whether this person is a follower of Islam or not? For example, my lords, can someone ask me that do you pray namaz 5 times a day? Otherwise, I will not permit you to make an endowment. That's an essential feature of Islam. Suppose some other Muslim is asked, do you drink? Will that be a criteria, my lords, for the purposes of saying that don't have it? And so far as contrivance is concerned, my lords, suppose tomorrow, my lords, someone wants to make a particular endowment. How will you determine, my lords, whether that is contrived or that is not contrived? That's the third aspect. And lastly, my lords, what I want to say is that so far as government properties are concerned, the injunction comes into force merely, my lords, upon a dispute being raised. There is no real formal adjudication which is required for this particular purpose.
That is already elaborately.
So therefore, my lords,
covered.
therefore, my lords, in sum, all that I'm saying is that so far as my lords 3D is concerned, its impact is drastic. My lords, it will apply to age-old mosques, age-old properties, and 3D, my lords, really requires an absolute stay for my respectful sir.
I appear in the 5th of the 5 lead matters. Only 4 have been. Lordship, I just have two points to make. That's all, Lordship. Not detailed submissions. 2 points which have not been made so far. Lordship, the first is.
Everybody says that, but then.
Lordship, and I'll keep my word, Lordship.
It's almost 3.5 hours. I'm not objecting, Lord.
No, 3 hours, 45 minutes.
Lordship, they require. It's already been stated.
I have come from Srinagar, my lord, only for this matter because most of the property of Wakf property is there in Srinagar. Please give me.
Lordship,
you include your points in the
clarification is listed.
Lordship, it has already been.
2 minutes. I will make question clear as far as Wakf is concerned.
How much time your side? How many? Who are going to argue?
5, but I'll start, my lord, and I'll cover, my lord, substantially, but will not take more than what they've taken. We can.
You can't. You should take lesser than that.
Yes, certainly.
So that we should give them some time for
points which were not brought to your lordship's notice, my lord, half sections, etc. I mean, I'll have to show, my lord, what is
Lordship,
the
I'll
real
just take a minute.
purpose, intent, object.
Lordship,
That's a very important point. So,
please.
I'm better. Better than his.
Now, there is a Wakf board also. Well, interestingly, one of the state Wakf board is before your lordship supporting this. I will point out, my lord. I'll point out.
Lordship, in a very quick minute, Lordship. Lordship, it's already been said that.
That's the only good.
My lords may grant us tomorrow, Mala, because
No, sorry.
there are good, important points which I have taken in
Lordship, mine is the 5th matter out of the lead
just
matter.
3 minutes, my lord. I will not take more than 3 minutes.
We had requested all
My
of
lord,
you
on the religious
time in 2 hours.
in the
We have
context.
given you almost twice of that.
Lord,
we
in
have
the
no
context of religious,
no
if your
control
lordship
over that,
would consider my application, everything has been detailed, my lord, everything has been spelled out in time.
Lordship,
Lordship may kindly give us tomorrow, my lord, 5 minutes.
Please don't do this.
2 to 5 minutes, my lord.
So you give your notes.
Lordship, I appear in one of the lead matters which have already been selected as a matter that have to be heard. Lordship, I'll just take 2
We had
minutes.
requested you to fix up timings among yourself.
Lordship,
Instead of 2 hours, we have already granted you 3 hours 45 minutes.
Lordship, as the youngest member of the family, that's not something I control, Lordship. So I'm just asking for 2 minutes of my lord and judges to make points which have not been made
Okay,
so far.
2 minutes by the
My
clock.
lord, 2
Very well.
minutes for me also.
Please.
Okay.
I shall be grateful. Grateful.
Okay, come.
Sir, lordship, I
Obliged. Now that that's a judicial order, my lord, we can do nothing.
Rather than having
The written submissions filed by the petitioners, my lord, contain several other issues, my lord.
Yes.
Lord, my apologies, my lord. Initially, my lord, when the matters were heard, there were three issues identified for the purpose of stay.
That's not
Because
true.
prayer is praying stay of the statute. Lord, I have filed my affidavit mentioning specifically that in view of the discussion which took place, I am filing this reply for the three issues. But the written submissions have come, which deals with, my lord, many other provisions also. My request would be, my lord, that kindly confine it to the three issues as already identified.
Well, I'm sorry, Malat. This is entirely, I'm sorry to say my great regard for my learned friend, Malat. Matter was listed earlier, then it came up later saying, the judge saying that I will, the Chief Justice, then Chief Justice said, I will hear the matter and see what further interim orders are to be passed.
No,
That's how the
Lord,
matter
all of
came
us
up.
were there.
I don't want, Malat,
All of us
we
were
have,
there.
we have made our submissions. We gave them in time to him. Malat, those matters are already in the petition, Malat. My learned friend can't say that I will only argue on three issues, Malat. I'm going to argue on the issues, Malat, that are, in fact, most important in the case, because this is a case of capture of the entire Wakf properties. That's what it is. But Mullah, I'm going to argue on all the issues. My learned friend can't say. He can.
The Lordships cannot be asked to have a piecemeal hearing. The Lordships really cannot be asked to have a piecemeal hearing.
hear him on this?
Substantive issues. 7, 8, 6,
Piecemeal,
7.
Lord, court
Learned
cannot
says
bifurcate.
confined to 3. That is my request.
Hearing only on the question of grant of indemnity.
Correct. That's also broadly, Mullah, I tell your lordship that.
3 points I have said, my lord, contemporaneously in my affidavit in reply, para 4, that at the outset it is respectfully submitted.
Where is that order? Where is that order?
Only a minute, Mr. Sibal.
No, no, but you are saying there's an order of the court. The
Please
court said
allow,
that.
this is not disputed, it is stated on affidavit.
His statement was
by an
limited.
officer who was present in the court, filing a prelim only to deal with the issues flagged during the earlier hearing on 16th April 25.
We were there, Mullah.
This is contemporaneously filed, contemporaneously reported everywhere. I leave it to your lordship. I wanted to flag this. This may not be fair to the court, and fair to the.
Neither of us is party to those. We are not aware as to what happened.
There was no truncation of issues.
There is none, Mullah. In fact, the order said,
No
we
dispute.
clarify. We clarify that the hearing fixed on the next date will be a preliminary hearing, and if required, interim orders will be passed.
Let's
This is
read,
nothing
my
to
lord,
do
the
with three
first order.
issues.
Let's read the first order. My lord, the first order which Mr. Sibal is reading, 17th April
Yes, yes,
25.
yes.
Yes, I'm reading that.
Please do.
Lord, please see. Your lordship, say, my lord, I'll, my lord, please.
Let him say what he has to say.
Lord, can I read, my lord? I'll just read, my lord, and leave it at that, my lord. This can't be the, not that we don't have answer to other questions, but this would be unfair to the court and unfair to the other side. During the course of the hearing, Mr. So-and-so, that is myself, stated that respondent would like to file a response within a period of 7 days from today. He assures this court that till the next date of hearing, no appointments would be made to the Central Wakf Council and Wakf boards. That was the first issue flagged, section 9 and section 14 respectively. Then I'm skipping because that's section 19, 14, etc. is mentioned. It is also stated that till the next date of hearing, no Wakf, including a Wakf by user, whether declared by way of notification or by way of registration, shall be denotified. But this is pertaining to section 3R, where we have deleted the Wakf by user prospectively from hereafter. We take these statements on record, rejoinder to be filed. Thereafter, my lord, the court directs that 5 will be the lead petitions. And it was 7 days because, my lord, it was 3 issues, my lord. And thereafter, my lord, the court at the end said, we clarified that the hearing fixed on the next date will be a preliminary hearing, and if required, interim orders will be passed.
That's all.
Lord, this is what, my lord, all of us were present.
So were
The
we.
court had flagged these issues, but my lord, I don't wish
My
to
lord,
my lord, embarrass the bench. It would be unfair, my lord, that's all I'm saying.
Can we go into that? Because if you are saying, all of us are saying that it was decided, they will deny it and you can't go
The
now.
denial would be unfortunate, but my
Well,
lord, I
in
don't
fact, the
want to.
statement is unfortunate, not the denial.
And we can't go and ask or other
No, sir.
creditors.
My lord, I don't wish, my lord, your lordship.
We will have to go by whatever is the record.
Yes, my lord, but I have said on affidavit that since these three issues were flagged, my reply is confined to three.
My lords, what happened was in the
And there is
fair,
no denial in
my
the
learned
rejoinder.
friend will realize what happened was the court came and the court said, look, give me an answer on these three. The court did not say, and that's why the court later said, you please argue the whole matter, and that's why it was fixed for interim orders.
The afternoon
That
hearing
was an
time was
afternoon.
proved,
Well, we-
brought. It's not that there were truncation of issues like this. This was done. It was then for continuation, in fact, for extending the orders on other points, either way. Not any limitation.
Anyway, as it is, we have paucity of time. Let's go on with the matter.
Plus, today the written submission is as virtually reading, arguing the entire writ petition itself.
Yes.
With all due respect.
Mr.
When the reply is confined only to three issues, plus their written submission.
We have given them 2 hours. They have to decide as to how they will.
That's why we want to start and let's
Yes.
finish, Mullahs, in 2
But
hours.
I just flagged it and leave it at that.
We can't go into that inquiry.
I understand.
We can't ask them run it. There is
It's unfortunate, but I leave it at that.
Normally we go by whatever is there in the black and white in the order sheet.
Yes, my lord, we sometimes trust, my lord, the other side will not take
Come on,
the
I mean,
first side.
no.
No, that's an unfortunate
For the
statement to make.
I don't know why.
That's an
Let's,
unfortunate.
Anyway,
So Mehta,
I leave it to, my lord, let them argue.
I'm feeling happy that I have only 6 more months left here.
We are not happy, my
So
lord.
by experience of 18 years in the High Court,
Lord, we have-
compared to the 6 years here, that's been much better.
My lord, that I can also say, my lord, for High Court, my lord, because I have also come from High Court, so is my learned friend.
But those practices are not being followed here, Mullahs, despite the fact that people come from the High Court.
Yes, my lord. So we learn wrong things, my lord, from our seniors.
That's the problem.
Yes.
Anyway, Mullahs, I think
Then let's proceed, yes.
let's proceed. Now, Mullahs, kindly just leave your paper book for the moment. I'll tell your lordships what the contours of my submission are. Mullahs, this is a case in which the 2025 Act has been framed, Mullahs, for the purposes of protection of Waqfs. But in reality, it is designed to capture Waqfs through a process which is non-judicial, through a process which is executive, through a process in which those to whom this property belongs, because Waqf can't be created without, except through private properties owned by the individual concerned. So private properties are being taken away only because there is some dispute. We don't know what the nature of the dispute is. And when that dispute happens, Mullahs, a person is appointed who is higher than the collector, and that person will decide the dispute on his own. He will give a report, but by the time, Mullahs, that report is given, we don't have the time frame. And within that, Mullahs, while that report is pending, the Waqf property is taken away. And
Taken away without following due process?
yes, and without following any procedure. I'll demonstrate all that to your lordships. Taken away with, and Mullahs, the dispute is whether this is government property or my property. He will decide that. He is a nominee of the government, Mullahs, who is higher than the collector. So the government decides its own dispute without any judicial procedure. And while that dispute is pending, while that report is pending, the property is taken away. It is no longer Waqf property. And there is no procedure. And anybody can create a dispute. So this is one aspect of the matter, which is in the context of what I say, it was designed to take over and capture Waqf properties. That's number one. Number two, Mullahs, what is a Waqf? A Waqf, Mullahs, is a endowment to Allah, to God. A dedication to Allah, to God. And that, pursuant to that dedication, that property can't be dealt with in terms of transfer. You can't transfer that property to anybody. Once a Waqf is always a Waqf. That's the very concept of a Waqf, Mullahs. In other words, if I have, Mullahs, in fact, dedicated my piece of property, because I cannot dedicate somebody else's piece of property. And the historical reason behind it, let me just tell your lordships that, is that, as your lordship knows, under our constitution, Mullahs, the state cannot possibly finance religious institutions. Cannot finance, Mullahs. If there's a mosque, Mullahs, the state cannot finance it for its upkeep. If, Mullahs, there is a burial ground, this has to be created through private property. So what happens is, Mullahs, that people at the end of their lives, Mullahs, give their private property dedicated to God. so that those who come later, Mullahs, can take advantage of that property. There are no earnings there, Mullahs. If you go to a burial ground, Mullahs, nobody earns. People come to bury their dead bodies, Mullahs, and they charge a certain amount through which they maintain that. If you go to a mosque, Mullahs, there's not a chadhava, Mullahs, like in temples. They don't have 1,000 crores, 2,000 crores, 3,000 crores, Mullahs. There are no chadhavas in mosques. So those have to be maintained. And how are they going to be maintained? Through the kind of monies that we collect through processes, Mullahs, of charity. That's all.
That happens in other religions also. When temples are...
No, but temples, Mullahs, people give, as your lordship knows, Mullahs, they are chadhavas that are given, Mullahs, and temples are, in terms of Mullahs,
but even in the
mosque,
I visit dargahs also, I visit churches also, everybody...
Dargahs and mosques, dargahs and mosques are different. Dargahs and mosques are different. I'm talking about a mosque, Mullahs. Your lordship is right. On dargah, it's different. But I'm talking about mosques. So what I was trying to say was, Mullahs, the ways to preserve these properties is through these kind of efforts that are made by the community, right? Now, Mullahs, what they say is that if anybody, supposing an encroacher creates a dispute, that property will lose its character as Waqf property as long as the dispute is pending. This is what the Act says. So you have a situation, Mullahs, where actually there was a Waqf Act. You just note this, Mullahs. There was a Waqf Act of 2013. 2013. Will you allow me? 2013, then, 1913, 1923, 1913, 1923.
What's in 1923?
1913, 1913, then 1923, then 1913,
1913, 1913,
1913, then 1923, then 1954, then 1984, then 1995, then 2013 and 2025. This is, Mullahs, the history of it. Yes.
Just factually, 84 and 2013 are amendments, not the...
No, I'm talking about the Act.
Yes.
Correct? So, Mullahs, therefore, and I will demonstrate to your lordships that the 2025 Act is a complete departure from the past. I tell your lordships how. There are two concepts in law called Waqf by user and a dedication, which is made, right? If you give a dedication, Mullahs, and you pass away, and that property is used, Mullahs, for the purposes of the dedication, it becomes a Waqf by user. And it's perpetuity. That's the concept of Waqf. Once a Waqf, always a Waqf. Correct, Mullahs? Now that Waqf by user has been done away. A concept that is recognized in the Babri Masjid case, saying Waqf by user is a practice, a religious practice, that has continued for hundreds of years. That's the 5-judge bench, Mullahs. And whether it's a Waqf by user or not is a matter of evidence. But they've done away with it. How have they done away with it? They say that in the 1913 Act, the 1923 Act, the 1954 Act, and the later acts, there was a requirement for registration. And because you did not register, Mullahs, therefore, any Waqf which is not registered will not be regarded as Waqf. So many of these Waqfs by users were created 100 years ago, 50 years ago, 200 years ago, Mullahs, 500 years ago. Where will you get them?
Is it a matter of fact that under those enactments, 1913, 1923, and so on, is there a requirement for registration?
There was.
So is it a mandatory or?
They shall be registered, they said. But Mullahs, the consequences of non-registration were not set up in the Act. The consequences of non-registration, this is the first time in the 2025.
I have not gone through anything because I had.
That's why, Mullahs, I'm broadly telling your lordships what my submissions are going to be.
I have not gone through. I'll be frank, so you'll have to start from ABCD.
Yes.
Just as a matter of information, as whether under the old Act,
yes,
the provision was for registration was mandatory or directly?
The expression used was shall.
Merely using shall may not make it mandatory.
Correct.
What were there any consequences provided in those acts for non-registration? If consequences are provided, then it will be mandatory. Whether word shall is used or not.
No, the consequences were not that it will not be regarded as a Wakf. That was never the consequence.
Was there anything that on account of registration of a particular?
You won't be regarded as, no,
something will happen.
no, there's no consequence that you will not be regarded as a Wakf.
But
It
there
will
were-
continue as a Wakf.
But there were consequences.
No, not this consequence.
No, but
No,
there were
no,
other
For the
consequences.
caretaker, there may be consequences, but not this.
We will record your submission
Yes, please.
that though under the old act, there were requirements for registration, but they were not mandatory because the consequences for non-registration were not provided under those acts.
For the purposes of deciding.
On account of non-registration,
Yes,
nothing was to be happen.
yes.
Like suppose if there is under certain act, mandatory duty is there. You have to do such and such thing within a particular period.
Correct.
And if you don't do that, then you will be required to pay 1,000 rupees fine or 1 lakh rupees fine. So no such provision is there.
No. The only thing was, Malas, that the act said that the Mutawalli who has not done it is made culpable. That's all. He loses his right to continue as a Mutawalli.
That's all. There
So
was
that's all. That I said to your lordship, and I stand by that. There were no consequences provided that it will no longer be regarded as Wakf.